Welcome to AI versus the law. If you want to follow along with the slides at your own leisure, there's a little QR code that you can fire up there. I'll have it up at the end if you want to retrospectively read what's going on. So first up, this is my first JS Conf. I'm so thrilled that they're back and I get to be here. And a big thanks to all of the volunteers and organizers and OpenJS Foundation for making this happen, because we all get to be here and I finally get to do one of these. So hi, I'm Ryan. I am the head of technology and open source at Nearform. I was originally with Formidable and then we got acquired. And so normally I'm a geek. At tech conferences, I talk about things like our open source portfolio, like Spectacle, a React.js presentation framework that I wrote this presentation in. I've got stickers, all the cool stuff for our open source, and even some t-shirts if you see me in the hall after. But today, we're going to take a little bit of a dark turn, because I used to be a former IP and patent attorney. In fact, I was a MoFo lawyer. And of course, what MoFo means is Morrison and Foerster. And they do have the domain mofo.com, much to the chagrin of our financial savvy New York-based partners. It was a San Francisco law firm, and what's kind of cool is very tech progressive. Some of the cases we will talk about today, some of my former coworkers at Mofo are representing. All right, so for me personally, what I've been keeping an eye on, I'm 20 years out of practice, it's long behind me, except for I still keep an eye on open source licensing. That comes up a lot in what we do in the JavaScript community. I've been really interested in legal tech, that intersection there. And then lately, you know, AI, copyright law, all of that, when we have this big collision, that's going to be kind of the fodder of the talk today. So as a kind of roadmap of where we're going to go, we're going to speed run copyright law. The first big segment we'll talk about is the inputs to AI and how IP and copyright comes up there. Then the outputs, what generative text actually generates, and for us that'll be code. And then finally, the future and some kind of roadmap topics. Now, as with anything, as a former lawyer, I have to give the admonitions and disclaimers. So first up, I am a lawyer, but I am not your lawyer. And if somebody out there actually knows all of the distinctions, I'm technically an inactive lawyer. My point is that I'm here to raise awareness, kind of get a few things on your horizon that you might not know about, maybe make some sense of some of the things you see when you're like, I heard there was a court case about this. I'm not here to provide answers or advice. Another thing I want to call out, I'm just going to be talking about US law and pretty much specifically code. I'm at a JavaScript conference. We're going to talk about JavaScript. There's a whole world of things going on outside those two limitations, and it's worth knowing that. And finally, if you do have these issues come up, go talk to your legal team. Go find yourself a real lawyer and then get some real answers. So without further ado, let's talk some law stuff. Okay, first up is copyright law. Now, I took an entire semester course, which I'm going to condense into 2 slides. As it's going to come up for us in most of these cases, copyright is a legal protection for the original creative expression of a work. It means basically not factual. That's how you can think of it. It provides exclusive rights to reproduce, distribute, and make derivative works, things that extend the original thing. For most of the cases we will talk about, there has been a primary finding of copyright infringement. One of these rights has been violated. So that gets us to the next thing, fair use. The most common defense and kind of the background of why we can still do neat things, a defense to copyright infringement. That is part of the US code. You can go read it if you want. US code, always fun to read when you need to relax. It is a 4-factor test that you kind of like put all these 4 factors in and then decide, hey, do they have a defense? Or is it still infringement and you have to have a legal remedy? So the first is the purpose and the character of the use. And that means, is your use of a copyrighted work something that's educational, benefits society, or is it just purely commercial? Does it transform and create something new that we didn't have before? And in the AI world, a lot of the uses are transformative. We get outputs that have nothing to do with the inputs, and so that's kind of cool. And copyright law wants to, in some sense, incentivize that. Second of all, the nature of the copyrighted work. Is it purely factual? That's more likely to be defendable. Is it more creative? That's a factor. The amount, are you using all or some of it? And finally, the effect upon the market value of the copyrighted work. Copyright law is all about incentives. I'm just going to speed past that and just leave that hanging out there. This is the main defense that we will talk about for most of the cases today. So let's start with inputs. For our inputs here is, what are you allowed to input into an AI system? For most of what we've been talking about, that means training data. Second of all, we'll call out a specific nuance. How about for web scraping? Because that gets kind of more techy and has its own kind of special analysis. And actually, I'll just give a punt here that Tracy just gave a wonderful speech. That covers basically all of it, so we're done there. Training data, first up here. So what materials are you allowed to train on? And what I do mean is, like, we'll just take the common case of a foundation model, has all of this data and input that go in, and then we get Claude can do your homework for you. So can you train on public domain works? Yes. Open source works? Mostly yes. There are some things you have to consider. Private copyrighted works where the author says no. Let's go see. And then finally, as an orthogonal thing here is, does the manner in which you collect and ingest this data actually matter? Why this matters to us here as predominantly engineers at a JavaScript conference is it'll impact what models and tools you can actually use. Is Claude going to get turned off? I hope not. And then secondarily is, if you're doing actual ML data pipeline and processing, this impacts how you will be able to gather and use that data. So let's dive in and let's talk some court cases. There's 4 we're going to talk about today. The first is Thomson Reuters versus Ross. It's being brought up because it's one of the first cases to get a holding. We'll talk about it in a sec. OpenAI litigation. This is covering OpenAI and ChatGPT. BART is covering the Claude models. And to round us out, so we're all inclusive, Kadri is going to cover the Llama models. Now, there's tons more litigation. I picked the ones that are foundation cases that you'll all kind of recognize, and because of how these decisions are going. So the first one up here is Thomson Reuters versus Ross. And it's befitting. Thomson Reuters has a legal tech product, and so does Ross. So the legal tech geeks are the ones who first went to court to battle each other, because that's how the lawyers roll. So Westlaw provides an enormous amount of public court data, but they provide their own little head notes, which is metadata, summarizing it. Ross copied those and ingested it into its own product, which was an AI legal search engine. And they did it without authorization. This got taken to the District Court of Delaware, so not too far away from us here. And in 2025, there was a holding of infringement. And most of these cases will find infringement. And then the secondary thing, no fair use, the defense analysis. What the court found there was that the use was commercial. Ross competes with Westlaw. And Westlaw, probably by this time, has it, but may well introduce its own AI legal search engine. So by using a competitor's inputs for your own competitive product, that mattered to the court. And they found that this directly harmed Westlaw's market. That's factor number 4 in the fair use test. And so thus, infringement, no fair use. And the status of this case is it's in appeals. So this is just an early one. The next one is, this was originally at least 5 different cases where the defendants are variously OpenAI and or Microsoft, and it has to do with the training that training data OpenAI ingests. The plaintiffs are all kinds of news companies, authors. We've got George R.R. Martin in there, Sarah Silverman, we've even got Scott Turow. Everyone's suing OpenAI. All these cases are now consolidated, and the status is just, it's kind of ongoing. It's just our placeholder to say we don't have a decision yet, and this stuff is all in development. One of the first ones we have that's a big decision is BART v. Anthropic. Now, this has to do with the Claude training data. And there were 3 sources of data, broadly speaking, that we can categorize that came into the Claude training data set. Online sources that were permissible, you can freely scrape, meet robots.txt, that's all fine. Pirated sources, they went over to like LibGen or whatever the successor to the Pirate Bay is, and went to unauthorized sources of digital downloads. And then finally, they went real old school here. They purchased books, probably, hopefully at the used bookstore, ripped off the covers, digitally scanned all of those, and also contributed to the training data. And in June of this year, we had the district court, Northern District of California, where a lot of this litigation happens, the first preliminary holding. And what it was that the non-pirated sources are all fair use, especially noting that the use of Claude is excessively transformative, so that helps with factor 1. However, they found that the pirated sources are not fair use, and because of that market harm factor, factor number 4, that you wouldn't get the fair use for the pirated sources. And this is kind of interesting because it's literally the same work you could get from LibGen or by the novel, but it's actually the process by which Anthropic went about getting that into digital format actually mattered. And that's somewhat interesting for us. And now, I think we probably all have seen this, but the latest status on this case is that Anthropic is proposing a $1.5 billion settlement to go for the authors whose works were pirated. I wrote a book on Backbone.js testing so long ago, but it's in the set, so who knows? Maybe I will become 100 or 1,000-aire from this settlement. And that's the status of this case. So now let's switch gears. This is mostly analogous, Kadri versus Meta. Again, in Northern District of California. You know, San Francisco likes to think of itself as the center of all the AI boom. It's also the center of all the AI legal boom, if you will. If you count litigation as that. So the facts are very similar. Permitted sources, pirated sources. However, the outcome was different. In June 25th, I think 2 days after the Bart's decision, the Kadri court came down and said that use was transformative, there was no market harm, and that everything's A-OK for Meta's use to train the llama models on. Now, there were some limitations because of how the plaintiffs presented their data, and the court in Kadri did note that, like, oh, our fellow judges across the hall just came out with a different decision. But as a lawyer, it's very interesting to note when you've got the same district court giving 2 different outcomes for what seems like a pretty similar fact scenario. So now we'll shift over, and then I'll kind of sum up where I think we are, which is to say scraping. And scraping's kind of its own beast. Now I get to go really fast because Tracy just gave a great talk on this here. Is the one thing I want to point out is there's a separate case against Anthropic. Actually, there's so many. But the one I'll point out here is Reddit is suing Anthropic for scraping and training on their data. The interesting thing for me here is that this one has to deal with non-copyright claims, tort, breach of contract. Don't worry, I'm not going to go through the law of those. But just know that it's different. And what they're trying to offer is that because there is a licensing path to get the Reddit data, Reddit's trying to make the AI model companies pay for the data they use. And they're going along those claims battles. It's still in early phases. Cloudflare and other edge providers are now providing bot protections, and there's really simple licensing and other schemes. And Tracy had 4 other things on her slides, and you should really go watch her talk as a summary of what I'd say is the business side and the technological side of this. So for our takeaways here, the courts are now split on fair use. And this is early days, and when this happens, what typically happens is the higher courts try to resolve the differences and give us something, but we don't know what everything means right now. We're just taking our best guess. So what the indications are is you don't necessarily need permission. Even in the Bart's case, where Anthropic was held liable, for the stuff that they scanned themselves, that was OK. I don't know if that'll hold long term, but you don't necessarily need full approval. The cautious course is to gather your data without pirating, and then be wary of using data from a direct competitor. That's the Ross case, and that's kind of a different set of facts for that reason. And then finally, in this world of change that we have with AI, you don't want the law, the legal system to be the decider of how things goes. What you really want is what Trace's talk was about. We're seeing more business and licensing solutions that kind of give a path that works for everyone. And that's going to happen at the same time outside of my talk. And in many ways, that's how we kind of resolve these disputes. Same in the early 2000s when digital copyright alone was this huge big thing. Anyone remember Napster and all the lawsuits? So it's kind of like that all over again. So that's the inputs. Take a little breath. Woo-hoo. OK. So now let's move over to the outputs. The things that, in this case, for us, it'll be generative AI and coding outputs What do we do with those, and how do we reason about them? So what happens when AI produces otherwise copyrighted content and code? And then secondarily, can AI-generated content actually be protected by copyright or be an intellectual property asset? So let's take number one up, infringement. So we probably all remember this. When GitHub Copilot first got introduced, it was first exuberance, yay, and then secondarily is like some folks started noticing, hey, this is actually producing like copyrighted code. And that can be a big problem to say you've got a private project or an open source project under like an MIT license, and suddenly GPL code gets spit out, and you didn't necessarily want to buy into that. There was even a lawsuit over that is still kind of plunking around, of course, Northern District of California again. But now GitHub and the other, most of the other code providers have at least some means or reassurances of guardrails to try and prevent the outputs being copyrighted code. So with this one, it's like kind of more of a business and technological solution as a broad theme. That lawsuit's still going to go on. And then the other thing I wanted to point out here is that this is not a unique problem to just AI. Long before we had the generative models for code, we had the copy and paste command, and we had Stack Overflow, and that's how a lot of code happened and a lot of risk happened. So there's existing tools that work pre-AI and post-AI, like Socket and then Black Duck, I remember way back in the day, to actually audit your sources, compare against a known corpus of code and its license, and then make decisions there. So this one is kind of more of a little bit tractable problem. We kind of know how to deal with this one because we have experience. So you need to be careful, but there are guardrails. Now let's get into the stickier problem, and that is ownership of AI-generated outputs. Is the code you create, you crack your fingers, fire up cursor, give your best prompt ever, and it spits something out, is that something you can copyright? If you use the tab completions, if you use the full IDE chat, does that matter? Well, I'd say why this matters is, first of all, you might directly care about copyright ownership. If you've got an open source project, the thing that makes the license you chose work is because you have copyright ownership over the project, and thus give the license, and that's how everything else kind of falls down from there. If you work for an employer, and many, probably most of us do, everything you write is an asset of the company, or like Nearform's a consultancy, it is our client's code, but that intellectual property asset in the code is very important because it signifies ownership, and it's part of like what all the contracts and businessy business stuff makes happen. So indirectly or directly, you care about, well, I'm posing that, but you should care about whether your output can have copyright protection. So let's talk about a first case. And actually, this is the only case I'll talk about in this one, which is that Perlmutter is the head of the US Copyright Office. Thaler is an inventor. And Thaler wrote an AI image tool that can generate images. And then Thaler went for a copyright registration on one of those images and submitted the AI tool as the author. And that's probably not setting yourself up for success. So the Copyright Office rejected the application, and moreover, went to court, and the court affirmed and said the holding is that the US Copyright Act requires human authorship. You can't have an AI be an author, and so that's there. The US Copyright Office, independently of this, has done a 3-part report on AI. The second part of the report is the one that matters to us here, and this has to do with the copyrightability of outputs. The report's long. Oh my God, it's long. I'll summarize. Purely AI-generated content is not protected. The second one is prompts and instructions alone are not sufficient. And for me, I'm going to do direct quoted language. Repeatedly revising prompts does not change this analysis or provide a sufficient basis for claiming copyright in the output. And that's an important one, because when we think of you fire up cursor, you do a little more in the chat window, it outputs a little bit more. I tend to think of that as, I'm coding, just a different way than if I was typing it up by hand. But according to this analysis, anything you type in the prompt window, if you take it to the extreme, doesn't count, and the outputs don't count. The only thing that can get copyright protection is the human control of the selection and placement. Now that's legalese for saying the human did it. Those parts can still have copyright protection. But it's an interesting thing now for us because what does that mean that the human actually interacts with it? And I think the Copyright Office, there leaves little room for ambiguity of this human control. Can that be through the AI means or mechanisms? Okay, we're 20 minutes in. We have done a ton of law. Let's take a little break. You know, Kent Dodds made everyone stand up and exercise. Since I've been blasting law at you, I will have us sit down and look at code instead to kind of refresh our minds and be like, okay, the law's going away. It's almost done. This will be okay. So here's our coding break, but I'm not too far away. Let's write ourselves a JavaScript CLI tool that will translate the license field in package JSON into a full license name. Fortunately, this is a pretty easy problem because all of the license data is available in the SPDX repository in one monstrous JSON file that has every license that's approved in the SPDX data set. And then I've got a detailed task description if you want to go do this on your own in slide 40. But in the interest of time, I'm just going to cut to my answer. OK, so I have code. I mean, this is not that tough of a coding assignment. Read the package JSON, fetch the SPDX data, just do a simple find in the array, and then use ternary to display our outputs, and voila, we translate MIT license field into MIT license. We could do other stuff too. But that's not enough. I'm going to do it again. OK, here's example 2. Needed to get things going, so I wrote it twice. This is pretty close to the previous example. I used some optional chaining throughout in lines 6 through 8. It's, kind of going back and forth between async await and then a thenable promise in the same chunk of code. And at the end, I use an if-then instead of a ternary. But wait, I did it the third time. OK, I'm fetching. It's pretty similar to the other examples, really kind of a mix. And so I think you can kind of guess what happened here. An AI wrote 2 of these. A human, me, wrote 1 of them, the one with the questionable .then thing, which probably seems like an AI artifact. But 2 of them are generated by an AI, Cursor and Copilot, and 1's by me. Here's the task description, which I did it the right way. I wrote out this task description first. I did it, and then I punched it to Cursor and Copilot. And so now we have human versus AI code. So what are the differences between these? If we look at the code, there's not much difference there. They're functionally equivalent. Now, there's a side issue of, like, is there creative expression in there? It's so basic. Let's just put that aside. What's interesting here is, though, going by that definition of the US Copyright Office, example number 2, the one I wrote, can have copyright protection, and the moment I went save, it was protected by copyright law. And examples 1 and 3 do not have copyright protection. And yet, they kind of do the same thing. And then I take the mental model further. At least how I do my cursor prompting and whatnot, I have a good idea of the code I want. And I sometimes go back and forth with, should I just type it out by hand because I know what I want? Or can I do the prompt to give me the code that I want? And if you have this like parallel worlds thing where I just do one parallel world human, one parallel world prompting through cursor, and then the output's the same, what's weird is by the law, only one of those scenarios gets copyright protection, and that is an interesting legal fact. That is, of course, like has scary ramifications, but for this talk, it's just interesting. And I think we can extrapolate this to larger pieces of code that even if this is too trivial to worry about copyright protection, I think it applies more generally. Now, another one that's really interesting here is how many folks have heard of spec-driven development? And how many folks have actually done some spec-driven development? OK, so this is kind of the phoenix rising from the ashes of vibe coding, which is that you, instead of just letting vibe coding do whatever, you put your PRDs, you put kind of like what you would do for Jira, stick it all in Markdown in your repo, and there's tools, AWS Kiro or Cairo, GitHub Spec Kit, and it produces the code for you. And in this example below, it's a different tool. There's a control comment header that says, for that tool, in fact, you are not supposed to edit the outputted JavaScript. And if we take this logical conclusion here, what's really interesting is by definition, the US Copyright Office would theoretically say that all of spec-driven development can't have copyright protection. And so that's interesting for me. What we have here is a real collision between the lawyering worlds and the engineering worlds. And I've seen this before back in the early 2000s with copyright laws. How many of you who are engineers, and it's okay if you don't want to raise your hand, use AI but have not received any legal guidance or any talk whatsoever about copyright protection of your outputs? It's most of what I see. And this goes including to the largest companies in the world. And yet the lawyer side of things seems to think is like, oh, the engineers would never do that. And so that, again, is interesting because we have this collision course. My hunch is, and this is, I'm no longer a lawyer, it's been 20 years since out of practice, there's got to be some give. There was something creative in that prompting, at least for how I think of it, that there will be something there, but we don't have it yet, and the lawyers are being really, really conservative on this one. So the cautious approach for right now is favor as much human involvement as possible. Go typey type and go fix things as much as you can. And then the other one is okay, what's the ramification if we don't have copyright protection? It's probably that whatever the outputted code is, it's public domain. So in an open source project, would it be okay if you had a mix of copyrighted and open and public domain work? I mean, you can copy public domain code right now and paste it into a project, private or open source, and it's probably okay-ish. But it just makes things more complex for us. So with that, let's talk about the future. This is just the beginning. I'm just going to give you a couple of bullet points before I go. There's another just kind of interesting discussion of we know what open source is, but it's having this ongoing evolution with source available licenses. And the newest one is the open weights. You can't recreate Claude, or you can't recreate Llama yourself, but you can get access to the weights and freely use with some constraints. What does that mean for us? It's more of kind of like an ongoing, the evolution of licenses and what open source means generally. So I'm not going to go more into it, just pointing out an interesting topic. AI beyond code. There's tons of litigation, tons of activity around images, video, both as inputs and outputs. There's AI in other areas, patents and trademarks, et cetera. So hopefully today, you learned a couple of new things, hopefully didn't get too freaked out, and just seeing things to think a little bit differently about, what does it mean to have the law with what we do for generating code and inputting. And so I will leave you with, the QR code will be on the final slide too. This deck is available there. It is a spectacle presentation. You can go see what writing your decks in code looks like and go fire that up there. And with that, I'll leave you with my final contact details, and I want to say a big thanks. Come find me in the hall. I've got some open source stickers, maybe a couple of t-shirts. I love to talk law, AI, code, or whatever, but yeah, so you made it through the law talk, and I just want to thank you very much. Yeah, so the question is I lobbed that grenade out and said, only the human authorship part is the protected part, and so the rightful question from there is like, okay, so what does that mean practically? Is 10% enough? How much does a human have to edit? Is just changing a comment? And the answer is, at least for the limited research I know, no, it's all the Wild West. We have no idea. And I think it's the thing I'd say is most hopefully, I think there has to be a reassessment of what prompting means to the outputs, because so much of if you ask an engineer, even who's using Claude Code, or are you producing, is the AI doing that without you? You'd say no. I am doing this, and the AI is a tool to get me there, and theoretically, copyright law should catch up to that, but it hasn't. And the other thing I think that is coloring this area of law is most of the cases so far, have been creating an image output, and those tend to be the things that are less tuned or whatever, and more like the AI just spits something out and you're kind of done, whereas code is more discrete. You do little chunks here and there, and I would hope that there's some difference. But to answer your question, no idea. I get to lob the grenade of say, oh, this is risky, and then not offer any helpful solutions.